Hi everyone, today we will do legal dictation exercise number 116. You can get the PDF from description box. So ready? Start. The question for consideration is as to whether it is permissible for an employer to fill any subsequent vacancy caused over and above the number of vacancies advertised, and in case the number of vacancies advertised stand filled, whether the selection process comes to an end and stand exhausted. In such an eventuality, there remains no sanctity to the wait list. As to whether it is permissible for the employer to fill up the future vacancies which came into existence subsequent to the conclusion of the selection process from the wait list so prepared. It is a settled legal proposition that the authority cannot fill up vacancy over and above the number of vacancies advertised, as it would amount to filling up the vacancies which have occurred in future, and that would be violative of the fundamental rights of the candidates who become eligible subsequent to the advertisement, as held by the Honorable Supreme Court in Union of India and ORS versus Ishwar Chandra. The Honorable Supreme Court quashed the appointment made over and above the vacancies advertised, holding that such an action was neither permissible nor desirable for the reason that it would amount to improper exercise of power, and only in a rare and exceptional circumstance and in the emergent nation this rule can be deviated from, and it can be done only after adopting policy decision based on some rationale, as the authority cannot fill up more posts than the advertised as the matter of course. The court further held that selected candidates have right to appointment only against vacancies notified, and that too during the life of the select list, as the panel of selected candidate cannot be valid for an indefinite period. Moreover, impaneled candidate in any event cannot have a right against future vacancies. It has been further held that a person does not, on account of being impaneled alone, acquire any indefeasible right of appointment. Impanelment is at the best a condition of eligibility for the purpose of appointment, and by itself does not amount to selection, and nor does it create a vested right to be appointed unless the relevant service rules provide to the contrary. In the said case, as the selection process was completed in 5 years after the publication of the advertisement, a contention was raised that the impaneled candidate deserved to be appointed over and above the vacancy notified. The Honorable Supreme Court rejected the contention, observing that it may not be justified, as offering the post in such a manner would adversely prejudice the cause of those candidates who achieved eligibility in the meantime. In view of the above, the law can be summarized that appointments cannot be made over and above the number of vacancy advertised, as it would be adversely affect and violate the fundamental rights of those who become eligible subsequent to the date of advertisement, in pursuance of which the select list is prepared. Thank you. Please subscribe my channel Steno Star.